An overview of the New York City salary band legislation for hiring officials and others responsible for employment recruitment at Einstein. On October 31, 2017, the New York City salary band legislation will go into effect. This is the new law that prohibits employers in New York City from asking about, relying on, or verifying a job applicant's salary history during the hiring and interviewing process. This also includes the negotiation of a contract. The ban also extends to relying upon salary history unless the applicant offers the information voluntarily. The law defines salary history broadly to encompass not just wages, but also benefits and any other form of compensation. The legislation follows a trend at the city and state level that is meant to remedy pay disparities for women and minorities and encourage employers to set compensation based on qualifications. This new legislation amends the New York City human rights law and makes any violation of it an unlawful discriminatory practice. Employers that are found to be non-compliant with this new legislation can be fined up to $250,000. Candidates have the right to pursue legal claims with the New York City Commission on Human Rights or directly in court. How does this law apply to how we recruit at Einstein? To begin that discussion, let's first review who the law affects and who is excluded. The NYC salary band law will apply to all employers in New York City regardless of size, as well as independent contractors. The law excludes current employees who are applying for an internal transfer or promotion with their current employer. The law will also exclude applicants for positions with public employers for which compensation is set pursuant to a collective bargaining agreement. The new measure will prohibit employers in New York City from asking applicants questions about or soliciting information about a candidate's current or prior earnings or benefits, asking a candidate's current or former employers or their employees about the candidate's current or prior earnings or benefits, searching public records to learn about a candidate's current or prior earnings or benefits, relying on information about a candidate's current or prior earnings or benefits to set their compensation. Although the law broadly defines salary history, there are a few key exceptions to the ban. Employers can make statements about the anticipated salary, salary range, bonus, and benefits for a position, inquire about a candidate's expectations or requirements for salary, benefits, bonus, or commission structure, ask about objective indicators of a candidate's work productivity in their current or prior jobs, such as revenue, sales, production reports, profits generated, or books of business, make inquiries to candidates' current or former employers, or search online to verify non-salary information such as work history, responsibilities, or achievements. Make inquiries about salary history that are authorized or required by federal, state, or local law. Verify and consider current or prior earnings or benefits only if offered voluntarily and without prompting the candidate during the interview process. As a best practice, employers should shift their focus to discussions about a candidate's expectations for the position as well as the salary range for the job. This will keep the focus on the candidate's skills and qualifications. There are penalties for employers that are non-compliant with this law. For employers that are found to be guilty of an unlawful discriminatory practice by the New York City Commission on Human Rights, an employer can be fined civil penalties of up to $125,000 for an unintentional violation and up to $250,000 if the violation is willful and malicious. In addition to civil penalties, an individual who is successful in the civil lawsuit may recover damages, attorney's fees, and/or penalties. Employers may also be subject to additional mandated training and posting requirements. For human resources, we have removed all inquiries in regards to salary and bonuses from our employment application. We will still include a question on the application regarding the candidate's expectation for the salary range of the position. Moving forward, we will be documenting when a candidate voluntarily discloses salary history and other compensation information. We are informing all individuals who are involved in the interviewing process at Einstein on the new law and providing guidance on best practices. We will continue to ensure that the existing process for setting compensation complies with New York's Equal Pay Act, which states employers should base pay on a candidate's qualifications and not on their gender. If you have any questions or need guidance on this new legislation, please contact Senior Counsel Dana H.C. Lee. To assist hiring officials and others responsible for employment recruitment, we have included the link for questions and answers, courtesy of Paul Hastings, LLP, for review.